afternoon, everyone, and thank you all so much for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Lorena Evans presenting for us. If you are unfamiliar with the format of this event, first, Lorena is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Lorena will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when we have no more questions, and regardless of where we are, we won't take any more questions after 4:20, and we'll have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Lorena to get us started.
Thanks, Marissa. Good afternoon, everyone. Happy New Year. As Marissa said, my name is Lorena Evans. I'm an attorney with Legal Aid of North Carolina, specifically on their Second Chance project. And I'm here today to talk a little bit about criminal record expunctions very briefly, just to give you all really the bare bones information about criminal record expunction in North Carolina. As Marissa said, I am an attorney, but I'm not your attorney. And so Legal Aid does not represent you. And so any questions that you ask, I would just ask that you keep them vague, because not only for your own, personal identifying information to keep that safe, I can't answer specific questions about your particular circumstances. And so if there is a question that I feel may be getting into too many specifics, I very well may likely skip over it. I will talk briefly at the end about how you may go about applying for legal aid services to see if you may be eligible. And then at that point, once you have a file open with us, if you're eligible for legal aid services, that would be the point in which somebody would be able to give you more specific advice about your circumstances. But today we're just giving information about criminal record expunction in North Carolina. So just a little bit about legal aid. Generally, we are a statewide nonprofit law firm, and we provide free legal services for civil matters and criminal expunctions to low-income people, with the goal to ensure equal access to justice and to remove legal barriers to economic opportunity. And so we're here today to talk about criminal record expunction, but there are a number of other listen and learn topics that are presented on other legal matters that Legal Aid handles. And so, like I said, today is criminal record expunction. There is a listen and learn for healthcare power of attorneys, wills, and advance directives. Benefits, which can cover Social Security, disability, SNAP, Medicaid, family law issues like simple divorces and child custody, and then at the bottom, tenants' rights. On our website, that is where you can review more information about listen and learns, and you can also sign up for those listen and learn presentations if you may have an issue that might fall into one of those categories, or you're just interested in learning more. These listen and learns are a great opportunity to do that. They're also kept on our Facebook page, and so if you're not available during that time, you can go back and watch prior listen and learns on those issues as well. So we'll start broadly about what an expunction is, and I'll just say overarching that expunction law is state specific. So we're in North Carolina. I'm a North Carolina licensed attorney. I can only speak to North Carolina law as it pertains to expunction. And so if you have out-of-state criminal matters or federal, that is not something that we will touch on today, nor is it something that we would be able to assist with here at Legal Aid, just because expunction is state specific. And so expunction just means to permanently remove an offense from a criminal record. And once an expunction is granted, the public criminal record of that offense is destroyed. And I think an important part about that is the public criminal record. We'll get into a little bit later about how there are certain entities that can keep record of expunged offenses or convictions. for specific purposes, but the overarching reason as to why those entities can do that is because their databases are not public. And so an expunction is permanently removing the public record of that offense, that dismissal, that conviction if eligible. And so if somebody were to go to the courthouse after somebody got an expunction, they shouldn't be able to search that individual's name, date of birth, information, and they shouldn't be able to see whatever was expunged from that person's record. And so if somebody is granted an expunction, that person can truthfully say that they were never charged or convicted of that offense. And that only goes for offenses or convictions that were expunged by the court. So there are three primary types of expunction, and expunction law is statute-based. And so there are a number of statutes that cover expunction law. There are really three primary types that we work with and we see on a regular basis. And so we'll start with the most broad, meaning if somebody applies for legal aid services, they're eligible, we open a file. Almost anybody that has a criminal record is likely eligible for the type of relief on the screen right here. And then as we go through the PowerPoint, that is when the law becomes more kind of tight, in that only a few number of people are eligible for that type of relief just based on the restrictions that are outlined in the law. And so by far the most common type of expunction is for dismissed and not guilty charges. And as it says on the PowerPoint, not guilty, that is any charge where somebody was found not guilty. Doesn't matter what the charge was. If somebody was found not guilty of that offense, that charge is eligible for expunction. The same thing goes for dismissed charges. If somebody is charged with an offense today, they go to court next week, and that charge is dismissed. The same goes for not guilty charges. Upon that final disposition of dismissed or not guilty, those offenses become immediately eligible to be expunged. Now, most charges that are dismissed after December 1st, 2021 should be automatically expunged 6 months after they are dismissed. And so typically for most other types of expunction relief, the expunction process is petition-based, meaning there is a form from the Administrative Office of the Courts that has to be completed and filled out with the information, and then that form then submitted to the court to begin the expunction process. But a law was enacted December 1st, 2021, that essentially made it for most dismissed charges to be automatically expunged 6 months after they are dismissed, to save individuals having to go through that petition process to get that charge expunged. And so most charges that are dismissed, like I said, after that date should be automatically expunged 6 months after the dismissal. Any charges that were dismissed prior to that date, however, will still require that individual to petition the court to expunge it. And so from that day onwards, that applies, but it's not a retroactive law. And so if you have charges that were dismissed prior to that date, they are still on an individual's record, and that individual would have to petition the court to expunge those, to have those removed from the record. And so, as you can probably imagine, most people that have a criminal record are likely to have some dismissed, some not guilty charges. Those are immediately eligible. There's no other requirements other than the charge was dismissed or that person was found not guilty of that offense. So we'll get into, I think, what most individuals are concerned about when they reach out for expunction assistance, and that is convictions. And these are offenses where somebody was found guilty or pled guilty, whatever the case may be. And so there is a statute that allows for the expunction of what we call youthful convictions. And these are most misdemeanor convictions and some felony convictions that were committed before December 1st, 2019, when somebody was 16 or 17 years old at the time of that offense. And this particular statute was written because prior to December 1st, 2019, many 16 and 17-year-olds who were charged with offenses prior to that date were being prosecuted and adjudicated in, I'll call it adult court, where just the regular criminal justice system where those records are public. December 1st, 2019 is when North Carolina raised the age of maturity, we'll call it in air quotes, to 18, meaning that if somebody were committing the same offense after that date and they were 16 or 17, they would likely be prosecuted and adjudicated in juvenile court where those records are sealed. And so as a way to provide some kind of relief for those individuals who had already been prosecuted, already been adjudicated when they were 16 or 17 years old for most misdemeanors and certain felony convictions, this type of expunction relief allows them to petition the court to have those convictions expunged, because if they were that same age today and they were charged with committing that same offense, it would be likely that even if they were found guilty, those records would be sealed, and your neighbor can go to the courthouse, use their public database, and find record of that offense and that conviction. And so these are most misdemeanors, some felony convictions, meaning Class H or I felony convictions that are committed before December 1st, 2019, when somebody was 16 or 17 years old at the time that the offense was committed. Doesn't matter when that person was found guilty or pled guilty. If they were 16 or 17 years old at the time that the offense was alleged to have been committed, it may be eligible for this type of relief. And then the most narrow type of relief that only a certain number of people are eligible for is the expunction of adult convictions, meaning convictions that occurred when someone was 18 years or older. These are some misdemeanors and certain felonies where someone was 18 or older. And this next slide is probably one of the most important slides, in that there are certain convictions that would prevent somebody from being able to expunge their adult convictions. And the law, as it's listed on the page right now, it's North Carolina General Statute 15A-145.5A. It's the very first part of the statute that speaks to the expunction of adult convictions. There is a list of alienated types of convictions where the statute essentially says if somebody has a conviction for any one of those designated offenses, they are not eligible to expunge any convictions that occurred when they were 18 or older. That doesn't mean that they still couldn't expunge youthful convictions, so those convictions where someone was 16 or 17, or any and all dismissed charges or not guilty charges that somebody has. But having a conviction for one of these types of offenses means that under the law, that person cannot expunge their adult convictions, and those convictions will stay on that person's criminal record. And there is quite an extensive list, and a lot of it just kind of refers to other statute numbers. And so for the purposes of this educational presentation, we have listed the most common ineligible offenses that we see, because there are some on that list that I haven't even seen, and I've been doing this work for a little over 2.5 years. And so all that to say, if somebody has a conviction for one of these types of offenses, bottom line is they are not eligible to expunge any of their adult convictions. But if they are eligible for youthful relief for those certain types of misdemeanors and felonies, or they have dismissed or not guilty charges, they could still petition the court to have those expunged. And so by far the most common, I think, are Class A through G felonies. And so common law robbery, for example, is a Class G. The sale of drugs is usually a Class G. If somebody has a conviction for either one of those offenses, plus any other offense that is designated Class A through G felony, that disqualifies someone from expunging their convictions. The same goes for any Class 8-1 misdemeanor conviction. So for example, misdemeanor child abuse, DVPO, protective order violations, also a Class A1 misdemeanor. Those would disqualify somebody. Any conviction that requires sex offender registration, that is disqualifying. Any offense where assault is an essential element, and that's usually fairly easy to spot because the word assault tends to be in the name of the offense itself. So assault on a female, simple assault. The one that might throw some people is simple affray. That also counts as an assault. So offenses where assault is an essential element, those are disqualifying. Any felony offense that involves heroin or crystal meth, those are disqualifying. And then another very common one that we see is possession with intent to sell or deliver cocaine. So PWISD cocaine convictions, those are disqualifying, which differs from the one above it in that mere possession of cocaine is not disqualifying, whereas mere possession of heroin or crystal meth is. For cocaine, for that particular drug, there needs to be some kind of further intent, whether that's intent to sell or deliver, or actually selling or delivering. That is what makes that disqualifying. And so, like I said, there are a few other ones. The statute at the top, if you were to Google that, that would take you directly to the law. But all of that to say, these are the most common disqualifying, meaning that if somebody has a conviction for one of those types of offenses, the convictions are going to remain on their record as they will not be eligible to be expunged. And it only takes one of these types of convictions to disqualify someone from expunging all of their adult convictions. And so it's not like just that one conviction is not eligible and someone could expunge the rest of their convictions. It only takes one of these to disqualify somebody from expunging any of their adult convictions. So I definitely understand that was a lot, and I see there are probably a couple comments and questions, so I'll be sure to circle back to any of those at the end. But all of that to say, as you can probably tell, the law is quite complicated, and it can get quite intricate depending on the length of somebody's record, the types of offenses that they have. And so there's a lot more information to it as well, but that is just the bare bones, kind of what I find most people who are interested in expunction want to know. And so I'll also just cover another important aspect, I think, is the process of expunction and what that looks like, because a lot of people don't know, and it varies county to county. And so this is kind of just broadly the steps in which most, if not all, expunction petitions follow. And so number one step is to obtain an accurate and complete record for yourself or for somebody else, if you're like me, for example, and you're an attorney. This isn't as easy as you might think or you might want it to be. There are at least 3 different public databases that we search at Legal Aid to hopefully find a complete record for an individual. The most important thing that we do once we have pulled somebody's record based on their name, date of birth, other demographic information, is we compile it and we are sure to review it with that individual to make sure that we have everything that we should be seeing, because that is the only way that you get to step 2 and you're able to determine the accurate eligibility for somebody in regards to what they may or may not be able to expunge. Another important part about getting a criminal record is knowing if somebody has out-of-state convictions, out-of-state charges, federal convictions, because while there's nothing that can be done about those in North Carolina, depending on what those offenses are, they can have an impact on what somebody may be eligible to expunge in North Carolina as it pertains to their North Carolina record. And so even from that statement alone, you can probably tell that it gets tricky and complicated. But ultimately, broadly, you want somebody's accurate and complete record, make sure that it's accurate and complete for that person. And then, as we do here at Legal Aid, as an attorney, we are essentially plugging in that person's record into the law to see what they may be eligible for based on that specific person's record. Once that happens, we're going to identify the correct petition, because there are different forms for each type of relief, and it is a standardized form that is online. It is one that the Administrative Office of the Courts created. And so there are different forms for each type of relief. So I want to make sure we're using the right form for the right type of relief. Sometimes there are additional documents that need to be submitted depending on the type of relief. And so if somebody is expunging adult convictions, for example, they will need to submit an affidavit on their own behalf. They'll need to have 2 character witnesses submit affidavits. And so depending on the record and the type of relief, there can be a number of petitions being filed in a number of places, because you not only have to file the correct petition form, you also have to file it in the county where that offense occurred. And so if somebody has a lengthy record that spans counties, those petitions can quickly add up, even if somebody only has 1 charge in each county. But because we have to file in every county, if that's where that offense occurred. For example, if you had an offense that occurred in Wake County, you couldn't file the expunction petition in Johnston County because that's not where the case happened. That's not where the case was adjudicated, whatever the outcome may have been. And so this can be quite a lengthy process, and there can be quite a lot of documents that are going around depending on the type of relief. Then we want to identify and follow county-specific procedures for filing. There are 100 counties in North Carolina, which of course means there are over 150 different ways of doing things. And each county is a little bit different on how they handle expunction petitions. And so if it is a county I'm not familiar with, usually I will call the clerk and ask them, I'm filing an expunction petition for this type of relief. What is the best way to get that filed? Some counties require you go in person. For attorneys, a lot of counties now, we have to file electronically. We may have to mail it in. So it really does depend on the county and the type of relief that that person is seeking. Then we determine and follow county-specific procedures. Some counties will review the petition and have the judge sign it in chambers, meaning that there's not a hearing. Some counties always require hearings, no matter the type of relief. It really does just depend on the county. And so if you have a lot of counties going on with petitions, this can vary from place to place. Then at the very end, hopefully if the petition is reviewed and granted by the judge, which means the judge is ordering the charges to be expunged, once that individual gets the verified expunction order back, which is the very same form that was originally filed, just with the judge's signature on the back, granting the expunction and the clerk's signature verifying that they have removed those offenses and notified other entities to remove reference of those offenses as well. Always just want to go back and make sure that that was actually done. And so the way to do that is go to the courthouse, type in that specific file number or file numbers on that form, and check to see if they've been removed. And if they have, nothing should show up when you type that number in. Now, this is at least 7 steps. This process can take a very long time. And again, it really just does depend on the county. We usually estimate for individuals who are clients of ours that may be asking, how long can I anticipate this taking? Really, if you're expunging convictions as well as dismissals, this process can take up to a year, if not longer. Just depending on the county, if you have a lot of counties where petitions are being filed, if you're in a bigger county versus a smaller county, I usually estimate to anyone I'm working with at least a year, especially if you're expunging convictions. If you're working with one county and you're only doing dismissed charges, I would anticipate getting that expunction through a lot quicker than that. But this is not a quick and easy process. It takes time, especially once petitions are filed, because then you're really just waiting to hear back from the courthouse. And there's no telling how long that might take, depending on the county. And so lastly, second to last, I want to touch on who can still have access to expunged records once they've been expunged and the reasons why. And so the 3 main entities that can still have access to these are the district attorney's office, so prosecutors, arresting agencies, and law enforcement. District attorneys' offices can see and they can use expunge records to calculate sentencing in the future if somebody were to be charged with another offense and subsequently convicted and they had a prior expunction. They can use that information when it comes to calculating sentencing. They can also use expunge records as it applies to somebody's habitual offender status. And so overarching for all of these entities really also is their databases are not public. So you or I or anybody that's not a prosecutor that doesn't work for an arresting agency that isn't in law enforcement couldn't log into their database and see this information. And so prosecutors, district attorneys' offices can use it for those purposes. Arresting agencies, they can maintain what are known as investigative records, even in the case of dismissed charges. And so they are not required to delete it from their databases, again, because they're not public. And law enforcement, they can also use expunge records for employment and certification purposes for individuals in the future. And so these are the three main entities that can still see expunged offenses or records and can still access them. Again, expunction is to remove an offense or a conviction from the public record. And so because their databases aren't public, that is one of the main reasons why they can still keep them for these purposes. I will just touch on very quickly. Today we spoke about criminal record expunctions very briefly, but our team also can assist with driver's license restoration. That is a very complex area of the law, and there's no way that we could probably do a community education presentation about that because that is very, 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 very individual specific. All of that to say, if somebody you know, or maybe you have a suspended driver's license and you're not sure why, or you're not sure how to go about fixing those suspensions, our team can also work on those. And at the very least, we can advise individuals who are eligible for legal aid services, and we can open a file for why their license may be suspended and advise them on the steps to take to hopefully get those suspensions lifted if possible. And so criminal record expunction and driver's license restoration tend to go hand in hand for a lot of individuals. And so if you also have questions or concerns about that, we may also be able to help with that. And so you may be interested in applying for legal aid services to see if you're eligible, and then we might be able to open a file for you. And to that point, in terms of our intake for the Second Chance project, our intake is still currently closed at this moment, but we are going to try a new format for applications beginning in February, the week of February 3rd, which is the first Monday in February. That whole week from February 3rd to the 7th, our intake will be open. And so I will instruct everybody just to check back on the website when it gets closer to that date. But once Monday, February 3rd hits, you can call into Legal Aid's helpline, and we will be opening the first 40 files that we are able to reach for those individuals who are eligible for legal aid services. It will be a first come, first serve, just because that's the easiest and the fairest way to get files open. And so the first 40 individuals that are eligible for services that would like assistance, we will be opening their files. And whether that's before the 7th, which is the end of the week, or before, once we hit that 40, our intake will be closed for that month. But we will open again the first week of March, which oddly enough, the 1st is also the 3rd of March. And for that week, we will be doing that same process. And so we're not opening any new files for the month of January, but if you are interested in seeing if you may qualify for legal aid services, I would check back on our website the week before February 3rd, and then February 3rd, you may call into the helpline and see if you're able to speak to our intake specialist to see if we might be able to open a file for you. And that goes for both expunction as well as driver's license restoration. And we can open both files for an individual if they're eligible and that's the services that they need. And so this is a new kind of way we are doing it. And so we are scheduled to do it for February and March and see how that goes. And so again, all of that to say, I would just check back the week before for any updates. And then you may call in February 3rd for that first week to see if we can open a file for you. That was a lot of me talking. And so I'm more than happy to take questions now.
Okay, we do have a couple questions in the chat. Just wanted to remind everyone, because I did see some raised hands, you cannot unmute in this forum. If you have a question, you need to type it in the chat. We will only be looking at questions typed in the Q&A box on Zoom or the comment section on Facebook. We will not be responding to any raised hands. So first are a couple questions about paperwork. Someone is wondering, where should they go to find the petition for expungement? Where do they go to find that paperwork?
Yes, all of the paperwork for really any kind of, well, most, if there's a standardized form for a legal process, it will be on the NC Court's website, and they have a tab at the top that says forms, and then they give you some like search criteria that you can put in. But that's where you can find all the forms as it pertains to expunction.
Next question is also about forms. Is the file number on the petition form the same as the case number? Should those numbers be the same?
Yes, the file number is the case number. So the file number is the court case number for that particular offense or offenses, depending on how many. But yeah, file number, case number, interchangeable words for the same thing. But yes, it should match. If you're seeking to expunge that particular file number, that file number should be on the petition.
And would someone check the district court box or the superior court division? I don't know if that's something you can answer. That might be a little specific.
Yep. Not too specific. That just depends on where the case was adjudicated, where it was heard, where it was disposed of. If it was in district court, you're going to want to check the district court box. If it was in superior court, that box is checked. And the reason for that is that, like I explained earlier, if you have charges in different counties, you're filing those petitions in those counties. But even once you get to that county, so someone has only Wake County charges, if you have district court and superior court charges, those have to go on two separate petitions because those are two separate court divisions. And so all district court charges that somebody is seeking expunction go on one form, all superior court charges go on another, even if it's in the same county. And so that's what that box is asking about.
Okay. Someone is asking, what is the eligibility criteria for legal aid? And
that is,
if you
Marissa, you might be able to help me out with that. That's
okay.
Not really a question that we can really answer because it depends on a lot of different factors like household, number of people in the household, assets, if somebody has any. It's all dependent on kind of financial eligibility just based on our federal funding. And so I can't give you a concrete kind of number or answer because that's why we have intake specialists who ask the questions and input the data, who could then tell us if that individual, based on their income, their household size, all of those kind of things, meet our eligibility.
That's actually a really good answer. Yeah, that's a really good answer. The only way I would expand on that is to say, essentially, you have to be income and asset eligible for most cases here in North Carolina, which means the income for the household has to be, below a certain amount, and it's based on gross income. So it's not based on what someone actually brings home, the check they actually, cash. It's what, their actual salary is. And assets is just, do you have, two homes or something like that? So as Lorena stated, it is very individually specific. So we can't give, you have, if you're making X amount of dollars and you're definitely going to be eligible. But those are kind of just the basics of the eligibility requirements for legal aid.
Yep.
And then also different kinds of cases have different requirements as well.
Yep. Thanks, Marissa.
Next question. Someone had their record expunged a couple years ago. They recently applied for a job at a prison, and that I guess that prison agency could still see their record. Why is that?
That might have something to do with the last slide that I just saw. or just went over. They're likely going to fall into the law enforcement and arresting agencies if I had to do my best guess. And so that's probably why they could still see that.
Would someone obtain their criminal background from the county/city they reside in, or from the state where they were convicted in?
In North Carolina, which I can only speak to, if you go to your local courthouse, there should be a kind of like public terminal, usually in the clerk's office or adjacent to, that somebody can search their name, date of birth, other demographic information, and it should generate that person's entire criminal record, depending on where those offenses occurred. All of that to say, because currently in North Carolina, there are two, because there's an old database called Cypress that North Carolina is transitioning away from to a new system called Portal. And so in some counties, well, in most counties, I think, if they still have Cypress, they should also have Portal terminals. And you can pull up charges from any of the 100 counties in North Carolina between those two databases to get a criminal record. If somebody goes up to the clerk, like the clerk themselves, and asks for a record, the clerk is only going to pull records from that county. But even in the same courthouse, if you go to that terminal, you should be able to pull everything from North Carolina generally. Now, that's not going to show anything else from out of state or federal charges. And so if somebody has either one of those, that's not going to be the complete record, but it should hopefully cover everything for that person in North Carolina.
I'm not sure if you know this offhand. Is a PWISD marijuana, I guess, conviction expungible? Don't know if you know
It's
that
going to
offhand.
depend on the particular record. I usually hesitate to answer specific questions like that because ultimately, to be able to give accurate analysis, you need to look at the whole picture of somebody's criminal record. And somebody tends to ask about one particular offense and don't mention anything else that they may have. And so that particular offense in and of itself is not one of the alienated disqualifying convictions. And so it could possibly be. It just depends on what else is on that person's record.
Um, Instruction. Okay. Wait, I'm gonna skip that one because I need to read it. Someone is asking about the website for the paperwork. I posted a link to the North Carolina Forms website that Lorena mentioned, so you can look at that link. If someone has charges in two different counties, would they need to file a petition in both of those counties?
Yes, if somebody has, let's say, for example, dismissed charges in Wake and Orange County, if they are seeking expunction of all of those dismissed charges, there would be at least one petition in Wake County for those dismissals that occurred in Wake County, and then another petition in Orange County for any of those dismissals that occurred in Orange County. And so think of it kind of like the county and the courthouse and the judges can only really hear and review expunction petitions for charges that occurred in that county and in that division, going back to district court versus superior court, if that's helpful.
How much does usual expunction range for someone, I guess, who's trying to look for a private attorney for just one that happened when they were a juvenile?
That is really going to depend. I never really know an answer to that just because it's not something that I am ever have to worry about or be concerned about, because if somebody is eligible for legal aid services and you become a client, those services are free to that individual. But the last time I spoke to a private attorney who did expunctions, really baseline, like minimum, even for dismissed charges, may be like $1,000. But that can quickly add up depending on how many petitions that attorney has to draft, how many counties they might have to go to. So unfortunately, it can get quite steep and pricey fairly quickly.
And then I am posting the number to, and actually, see if I can also pull up the website, to the North Carolina Referral Service, Law Referral Service, which has information for private attorneys. If someone's looking for a private attorney, you might be able to find some additional information there. And then,
Thank
Lorraine,
you.
I don't know if you can see your chat messages, but I sent you a message about one of the questions in the chat.
Okay, I'm just gonna stop sharing my screen for a second. Um, yeah, I'm not sure I can answer that question specifically, but I will just say that, again, in terms of applying for second chance, expunction, driver's license restoration services specifically, check back the week before February 3rd, and then you can call in February 3rd through the 7th to see if we might be able to open a file for you and be able to see if you're eligible for legal aid services and provide any further assistance at that point if we're able to.
Last couple questions. One of the lines on the petition form says that someone will obtain their criminal history record. Does that mean they still need to provide a copy of their report? I think that's what that question means.
So when somebody files an expunction petition, they do not need to submit their criminal record to the court at that point. I think really the form that I'm gonna guess this person is talking about is the expunction of convictions, because what happens for dismissed charges, not guilty charges, and youthful/raise the age convictions is they get filed, they get reviewed, and because having potentially disqualifying convictions don't affect someone's eligibility for those types of expunction relief, they can just be reviewed without having to pull somebody's entire criminal record. When somebody is petitioning for the expunction of adult convictions, once it is filed, it is actually sent off to the State Bureau of Investigation for them to essentially compile all of the criminal records they have for that individual and submit those records back to that court, to the county where that person filed the documents, and the judge reviews it once they are reviewing the petition, whether that's in a hearing or in chambers, essentially provides that person's whole record to confirm and make sure that they don't have a disqualifying conviction and that they meet all of the statutory requirements as laid out in the law. And so all of that to say, an individual, a petitioner, aka the person submitting the petition, does not need to supply that information, because if it's needed, the court will get that. They obviously need it to be able to complete the form correctly, but they don't have to submit that to the court, which I think is what that question is asking. So hopefully that's helpful.
Do you have any insight on about how fast Wake and Johnston counties move on expungements?
That's
different.
Yeah. It really depends on the type of expunction. I will say Johnston County can take a long time. And so on really any type of expunction. And so I wouldn't anticipate having things back from Johnston County relatively soon, but Wake County, I think, can operate a little quicker, but it really does depend on the type of expunction and things like that.
Where would someone submit their petition after they filled it out online, and does it have a cost?
So if you are filing pro se, meaning on your own behalf, probably print the petition and take it to the clerk's office where it needs to be filed. For dismissed and not guilty charges, most of the time there should not be a filing fee. However, in certain circumstances, let's say somebody has a charge that was dismissed via a deferred prosecution, meaning somebody was charged with an offense. The district attorney said, hey, if you complete 5 hours of community service and take this anger management class or something like that, we will dismiss the charge that the offense you were charged with. And so if somebody has a dismissed charge that came about through that kind of process, there is a $175 filing fee, but there is a petition known as a petition to proceed as indigent that somebody can file that can allow the clerk to waive that fee. That's not a guarantee. And in some cases, the clerk may ask for other financial information to really assess if somebody is unable to file that $175 fee. If you're a client of legal aid, purely by being a client of legal aid and we file a petition on your behalf, we can sign as the attorney to allow the clerk to waive that fee, but otherwise anybody can file that petition to ask the court to waive it. It's just not a guarantee that it will be. And for youthful convictions, that filing fee is $52.50, which can also be waived possibly by that indigency petition, and then adult convictions, that is also $175, but that too can possibly be waived by filing that indigency form.
And then just to tack on, if I may, about the indigency petitions, if you receive a SNAP/food stamps, SSI, or temporary assistance for needy families, TANF, those could also be reasons to have a filing fee waived under that indigency petition Lorraine mentioned. Kind of going back, this question follows up with, I think, what you were discussing. Someone is asking, is it possible to expunge dismissed charges that came about due to a plea agreement?
Yes, if a charge is dismissed or someone's found not guilty, if that's a final disposition, somebody wasn't convicted of that, those dismissed charges can be expunged. If it's via a plea agreement, like maybe someone pled guilty to one charge and the district court agreed to dismiss the other two, that person can still expunge those two dismissed charges. That conviction either will remain or they would have to file a separate petition if that conviction was also eligible. But yes, doesn't really matter how the charge was dismissed. If it was dismissed without leave by the court, by the DA, or someone was found not guilty, those are eligible to be expunged.
If someone submits their expungement materials, but they find out maybe something was missing, would the clerk return the packet and the fee and tell them what they were missing? Or what happens if their petition packet wasn't complete?
That is going to depend on the county. And it's probably easy for me to say this, but I do always kind of stress and encourage, if there is any way for somebody who is interested in possible expunction to speak to an attorney before someone starts filing all this paperwork, that is obviously best and ideal. Just because of, situations like that, some clerks may alert the individual, some might not. It really just does depend on the county. And so that's why it's really important to make sure that information is correct. And that all stems back to getting that accurate record from the beginning. And so it really does depend on the county. Some might just see it through without even letting that person know, depending on what may or may not have been missing. And so I can't really give a concrete answer to that.
Couple questions. Do you have any recommendations for someone who has, I'm assuming, a misdemeanor conviction on their record, and both probation officer and others have pointed out that it should have been a dismissed offense as it was a first offense? Do you have any recommendations for that? Not sure if you can answer that.
That is not something that we would be able to assist with here at Legal Aid. But Marissa did put the lawyer referral service number, and so I would probably recommend that if that is a scenario that you might find yourself in, giving them a call and getting a consultation, I think for $50 possibly, because that's not something, unfortunately, we would be able to kind of do much about. Even if that were to be the case here at Legal Aid, that's just beyond the scope of the work that we do here.
And then last question, if someone is running out of room, I guess they have a lot of case numbers or dates that they need to put on their forms, and I guess there's not enough lines, how would they fill that out? if there's just not enough
Yes,
space.
that's a great question. There is an expunction addendum form that you can attach to any of the initial expunction forms, no matter the type of expunction, that you can add as many as needed, and that form is also on the NC Court's website. And so if you have a form where you have more charges than fits on that first form, you can just supplement it with as many additional addendums as you need.
Perfection. Well, I have not seen any more questions, so I'm going to go ahead and thank you all for joining us, with a special thanks to Lorena for presenting and for answering all those questions. If you would like to review, oh, hold on. Okay, that's beyond the scope of what we're discussing here. If you would like to review anything we talked about today, we have posted a recording of today's event to our Facebook. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com/legalaidnc. If you would like to register for one of our other Listen and Learn presentations that Lorena mentioned at the beginning, excuse me, I also put in the chat a link to our Eventbrite as well as our page with all of our registration information for other Listen and Learns. Thank you all so much, and I hope everyone has a great rest of their afternoon.
Thanks.